The Judicial Department.
Section 109. The Judicial Power. Unified System. Impeachment. The judicial power of the Commonwealth shall be vested exclusively in one court of justice, which shall be divided into a Supreme Court, a Court of Appeals, a trial court of general jurisdiction known as the Circuit Court, and a trial court of limited jurisdiction known as the District Court. The court shall constitute a unified judicial system for operation and administration. The impeachment powers of the General Assembly shall remain inviolate. In 1975, by approving a major amendment to the current Constitution, the voters adopted a unified judicial system. The amendment encompassed sections 109 through 125, fundamentally changing them, concerning the Judicial Department and the Court of Appeals, and repealed sections 125 to 139 and sections 141 and 143, which had dealt with circuit, quarterly, county and justices' courts. Under the old system, the Court of Appeals constituted the court of last resort, while the circuit courts formed the highest trial courts. Below the circuit court were a number of other trial courts with overlapping jurisdiction: county courts, quarterly courts, police courts, and justices' courts. Although only attorneys could serve as judges of the Court of Appeals, the circuit courts and police courts in larger cities, non-attorneys could, and often did, serve as judges of the other courts. These latter judges were mostly paid by fees from court-imposed fines. The General Assembly did not expressly grant the Court of Appeals rulemaking authority until 1952, in civil cases, and 1962, in criminal cases, although that court had claimed such a power as inherent to its functioning. In 1954, the legislature created the Office of Administrative Director of Courts to be supervised by the Chief Justice of the Court of Appeals, but did not give it the authority to reduce case backlogs or to coordinate judicial activity. The 1975 amendment renamed the Court of Last Resort as the Supreme Court, created an intermediate appellate court to be known as the Court of Appeals, retained the Circuit Court as the trial court of general jurisdiction, and consolidated the trial courts of limited jurisdiction into a single tribunal called the District Court. The new judicial system is a unified one, with all of the courts forming one court of justice, and with the Chief Justice of the Supreme Court as its head, being empowered to coordinate the judiciary with support from an enlarged administrative office of the courts. The amendment also gives the Supreme Court authority to certify the necessity of changing the districts of the Circuit Court and District Court, and the necessity of increasing the number of circuit and district judges. The Supreme Court, too, prescribes the administrative duties of the chief judges of the districts of the Circuit Court and the District Court. The amendment requires all judges to be lawyers, and to be paid from state funds. A number of proponents of court reform, including the Governor's Judicial Advisory Council, the Steering Committee of the Kentucky Court of Appeals, the Courts Committee of the Kentucky Crime Commission, the Judicial Article Committee of the Kentucky Bar Association, the Interim Committee on Elections and Constitutional Amendments of the Kentucky General Assembly, the Kentucky Citizens for Judicial Improvement, and Kentuckians for Modern Courts, worked effectively in behalf of the judicial amendment. The Kentucky Supreme Court has invalidated a statute that prohibited the judiciary from enjoining an order of the Alcoholic Beverage Board that revokes a liquor license while such an order is being appealed, in part because the statute violates Section 109, which vests judicial powers exclusively in the Court of Justice, in Smothers v. Lewis, 1984. Similarly, the Kentucky judiciary has cited Section 109 in holding unconstitutional a statute requiring the Attorney General to approve appeals by the Commonwealth in criminal cases, in Commonwealth v. Schumacher, 1978. Section 109 also vests in the District Court statewide jurisdiction, and therefore a district judge can issue a valid search warrant at any point within the Commonwealth, in Richmond v. Commonwealth, 1982.
Section 110. Composition, Jurisdiction, Quorum, Special Justices, Districts, Chief Justice. 1. The Supreme Court shall consist of the Chief Justice of the Commonwealth and 6 associate justices. 2. A. The Supreme Court shall have appellate jurisdiction only, except it shall have the power to issue all writs necessary in aid of its appellate jurisdiction, or the complete determination of any cause, or as may be required to exercise control of the Court of Justice. b. Appeals from a judgment of the circuit court imposing a sentence of death or life imprisonment or imprisonment for 20 years or more shall be taken directly to the Supreme Court. In all other cases, criminal and civil, the Supreme Court shall exercise appellate jurisdiction as provided by its rules. 3. A majority of the justices of the Supreme Court shall constitute a quorum for the transaction of business. If as many as 2 justices decline or are unable to sit in the trial of any cause, the Chief Justice shall certify that fact to the Governor, who shall appoint to try the particular cause a sufficient number of justices to constitute a full court for the trial of the cause. 4. The Court of Appeals districts existing on the effective date of this amendment to the Constitution shall constitute the initial Supreme Court districts. The General Assembly thereafter may redistrict the Commonwealth, by counties, into 7 Supreme Court districts as nearly equal in population and as compact in form as possible. There shall be 1 justice from each Supreme Court district. 5. A. The justices of the Supreme Court shall elect one of their number to serve as Chief Justice for a term of 4 years. B. The Chief Justice of the Commonwealth shall be the executive head of the Court of Justice, and he shall appoint such administrative assistants as he deems necessary. He shall assign temporarily any justice or judge of the Commonwealth, active or retired, to sit in any court other than the Supreme Court when he deems such assignment necessary for the prompt disposition of causes. The Chief Justice shall submit the budget for the Court of Justice and perform all other necessary administrative functions relating to the court. The Judiciary Amendment of 1975 changed the name of the Court of Last Resort from Court of Appeals to Supreme Court. It retained the same number of justices, 7, and also the appellate districts from which they are elected. The original section provided that the senior justice would be Chief Justice. The amended section specifies that justices shall elect one of their number as Chief Justice. The amended section also makes the Chief Justice the executive head of the Court of Justice and empowers him or her to appoint administrative assistants as necessary and to assign members of his or her court or of lower courts to sit in any court where there is a need for a jurist to promptly dispose of a case. The Chief Justice must submit a budget for the Court of Justice and take care of other administrative functions necessary for the operation of the court. The Kentucky Supreme Court has ruled that Section 110 gives it exclusive jurisdiction to hear and determine any cause that has as its ultimate objective a judgment declaring what the court must do or not do, and therefore that it could hear a case involving a petition brought by a public defender to inspect data assembled by the court regarding the imposition of the death penalty in Kentucky, in Ex Parte Farley, 1978. The court also ruled that Governor Brereton Jones's participation in healthcare reform did not invalidate his appointment of 3 special judges to the Supreme Court to hear a challenge to the unconstitutionality of a Medicaid provider tax on physicians, 3 regular members of the court having recused themselves from the case, in Commonwealth Revenue Cabinet v. Smith, 1994. The court has ruled that under Section 110, a petition for mandamus or prohibition seeking to enforce or prevent an action by a circuit judge in a post-conviction proceeding is addressable to the Court of Appeals and not the Supreme Court, in Williams v. Venters, 1977. Under Section 110, 2b, the Court of Appeals does not have jurisdiction to hear appeals in which a sentence of 20 years or more has been imposed, and such appeals may be transferred by order and recommendation of the Court of Appeals to the Supreme Court, in Shepard v. Commonwealth, 1987. Further, the court has upheld, under Section 110, 5b, the Chief Justice's appointment of a district judge as a special judge of the Jefferson Family Court with powers to dissolve marriages, in Cuprian v. Fitzgerald, 1994.
Section 111. Composition, Jurisdiction, Administration, Panels. 1. The Court of Appeals shall consist initially of 14 judges, an equal number to be selected from each Supreme Court district. The number of judges thereafter shall be determined from time to time by the General Assembly upon certification of necessity by the Supreme Court. 2. The Court of Appeals shall have appellate jurisdiction only, except that it may be authorized by rules of the Supreme Court to review directly decisions of administrative agencies of the Commonwealth, and it may issue all writs necessary in aid of its appellate jurisdiction, or the complete determination of any cause within its appellate jurisdiction. In all other cases, it shall exercise appellate jurisdiction as provided by law. 3. The judges of the Court of Appeals shall elect one of their number to serve as Chief Judge for a term of 4 years. The Chief Judge shall exercise such authority and perform such duties in the administration of the Court of Appeals as are prescribed in this section, or as may be prescribed by the Supreme Court. 4. The Court of Appeals shall divide itself into panels of not less than 3 judges. A panel may decide a cause by the concurring vote of a majority of its judges. The Chief Judge shall make assignments of judges to panels. The Court of Appeals shall prescribe the times and places in the Commonwealth at which each panel shall sit. The Judiciary Amendment of 1975 created an intermediate appellate court, the Court of Appeals. The Court of Appeals consists of 14 judges, 2 for each appellate district. The judges elect one of their number chief judge, and he or she then assigns his or her colleagues to panels of 3. These panels perform the business of the Court of Appeals, hearing appeals from circuit courts, district courts, and certain administrative agencies. The Kentucky Supreme Court has ruled that Section 111 provides the Court of Appeals with inherent power to issue orders that are needed to deal with cases over which it has jurisdiction and, therefore, that the Court of Appeals could halt further administrative proceedings on an application for construction and operating permits for a solid waste landfill pending final adjudication of a judicial appeal challenging the issuance of the permits, in Green Valley Environmental Corporation v. Clay. 1990, the Supreme Court has ruled that the Court of Appeals has no authority to consider an original action for a declaratory judgment nor an original action to grant injunctive relief compelling the trial court to provide a newspaper with access to a sealed court file. Since Section 111 limits the court's jurisdiction to appellate matters only, in Courier-Journal and Louisville Times Company v. Pierce, 1988. However, the Supreme Court also ruled that the Court of Appeals has jurisdiction to hear a petition for an order compelling the performance of an official duty when such an order is necessary to implement its appellate jurisdiction, and hence the Court of Appeals could order a circuit judge to proceed with a divorce trial, in Francis v. Taylor, 1980.
Section 112. Location, circuits, composition, administration, jurisdiction. 1. Circuit court shall be held in each county. 2. The circuit court districts existing on the effective date of this amendment to the Constitution shall continue under the name judicial circuits, the General Assembly having power upon certification of the necessity therefore by the Supreme Court to reduce, increase or rearrange the judicial districts. A judicial circuit composed of more than one county shall be as compact in form as possible and of contiguous counties. No county shall be divided in creating a judicial circuit. 3. The number of circuit judges in each district existing on the effective date of this amendment shall continue, the General Assembly having power upon certification of the necessity therefore by the Supreme Court, to change the number of circuit judges in any judicial circuit. 4. In a judicial circuit having only one judge, he shall be the chief judge. In judicial circuits having 2 or more judges, they shall select biennially a chief judge, and if they fail to do so within a reasonable time, the Supreme Court shall designate the chief judge. The chief judge shall exercise such authority and perform such duties in the administration of his judicial circuit as may be prescribed by the Supreme Court. The Supreme Court may provide by rules for administration of judicial circuits by regions designated by it. 5. The circuit court shall have original jurisdiction of all justiciable causes not vested in some other court. It shall have such appellate jurisdiction as may be provided by law. 6. The Supreme Court may designate one or more divisions of circuit court within a judicial circuit as a family court division. A circuit court division so designated shall retain the general jurisdiction of the circuit court and shall have additional jurisdiction as may be provided by the General Assembly. A note from the Legislative Research Commission, which contained the text of the amendment to this section that was ratified on November 5, 2002, also contained Section 2, which reads as follows. District judges elected for the term beginning on the first Monday in January of 2003, who possess the qualifications of a circuit judge and who are assigned by the Chief Justice to serve as family court judges on or before the commencement of the term, shall on that date become circuit judges with terms of office coinciding with the terms of circuit judges generally, and another numbered division or divisions of that judicial circuit shall be created. When a district judge becomes a circuit judge pursuant to this provision, that district judgeship shall be abolished and there shall be no vacancy to fill. The General Assembly, upon the ratification of this amendment, shall enact legislation to implement the provisions of this amendment in a manner consistent with the Supreme Court's adjustment of any circuit court division as a family court division. The Circuit Court continues under the Judicial Amendment of 1975 as the principal trial court of the Commonwealth, having exclusive jurisdiction over the trial of serious crimes, or felonies, and civil cases involving amounts in excess of $4,000. It also hears appeals from District Court. Circuit districts remain the same unless changed by the General Assembly upon certification of the Supreme Court, which can also certify the need for more legislatively created judgeships. Each judicial circuit shall have a chief judge to be elected biennially by the circuit judges of the circuit. The chief judge shall perform such administrative duties as prescribed by the Supreme Court. The Kentucky judiciary has ruled that the circuit court has jurisdiction over a criminal case even though the suspect has not been indicted and may issue an order to the police to stop questioning the suspect until he has benefit of counsel, in West v. Commonwealth, 1994. The Circuit Court also has exclusive jurisdiction over a defendant once he or she has been indicted for a felony, and the District Court may not subsequently accept his or her plea to a reduced charge, in Commonwealth v. Hamblin, 1981. Similarly, the jurisdiction of the Circuit Court extends to both misdemeanors and felonies when parties have been indicted for allegedly committing both classes of crime, and a circuit judge may not refuse to try the misdemeanors but rather must try them along with the felonies, in Keller v. Commonwealth, 1980.
Section 113. Location, districts, composition, administration, trial commissioners, jurisdiction. 1. District court shall be held in each county. 2. The circuit court districts existing on the effective date of this amendment shall continue for district court purposes under the name judicial districts, the General Assembly having power upon certification of the necessity therefore by the Supreme Court to reduce, increase, or rearrange the districts. A judicial district composed of more than one county shall be as compact in form as possible and of contiguous counties. No county shall be divided in creating a judicial district. 3. Each judicial district created by this amendment initially shall have at least one district judge who shall serve as chief judge, and there shall be such other district judges as the General Assembly shall determine. The number of district judges in each judicial district thereafter shall be determined by the General Assembly upon certification of necessity therefore by the Supreme Court. 4. In a judicial district having only one judge he shall be the chief judge. In those districts having two or more judges they shall select biennially a chief judge, and if they fail to do so within a reasonable time, the Supreme Court shall designate the chief judge. The chief judge shall exercise such authority and perform such duties in the administration of his district as may be prescribed by the Supreme Court. 5. In any county in which no district judge resides, the chief judge of the district shall appoint a trial commissioner who shall be a resident of such county, and who shall be an attorney if one is qualified and available. Other trial commissioners with like qualifications may be appointed by the chief judge in any judicial district upon certification of the necessity therefore by the Supreme Court. All trial commissioners shall have power to perform such duties of the district court as may be prescribed by the Supreme Court. 6. The district court shall be a court of limited jurisdiction, and shall exercise original jurisdiction as may be provided by the General Assembly. The Judiciary Amendment of 1975 abolished the quarterly courts, the police courts, the county courts, and the justice of the peace courts and created the district court in their place. The county judge became the county judge executive, who is the administrative head of county government with no judicial powers. The justices of peace, who likewise lost their judicial powers, in many counties serve with the county judge executive as the fiscal court, which handles the financial business of county government. Each circuit court district shall have at least one district judge. The district judges of a district shall biennially elect one of their number chief judge. In counties without a resident district judge, the chief judge shall appoint a trial commissioner. Pursuant to Section 113, the General Assembly has granted jurisdiction to the district court to try less serious crimes, or misdemeanors, civil cases involving amounts of $4,000 or less except matter affecting title to real estate or matters of equity, uncontested probate matters, that is, wills and estates, and certain juvenile cases. Moreover, pursuant to Section 113, the Kentucky Supreme Court has authorized the chief judge of each district to appoint a trial commissioner in counties that have no district judge and in counties where the district judge cannot handle all of the judicial business. The court has further empowered trial commissioners to perform many of the same functions as district judges. Where a defendant is indicted separately for a misdemeanor and for a felony, the district court has jurisdiction over the misdemeanor, and it is wrong for the circuit court to try the misdemeanor as well as the felony. The same rule applies if the two offenses are subsequently joined and the felony charge is dismissed, in Jackson v. Commonwealth, 1991. Although a district judge's search warrant may be issued anywhere within the Commonwealth, a trial commissioner's warrant is valid only within the district, in Commonwealth v. Shelton, 1989. If a trial commissioner is an attorney, he or she is not prohibited from practicing law as is a district judge. A district court has no power to remove a fiduciary such as a guardian or trustee where issues of fraud, mismanagement, or deception are involved. Such cases need to be taken to the circuit court, in Lee v. Porter, 1980.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution by Robert M. Ireland, Oxford University Press.